Welcome to the Hamilton County Youth Court training session. We're excited to have you. My name is Katie Miltner, and with me is Anthony Holman, and we're both attorneys who help to coordinate the youth court program. We've created this training video so that you can complete the training at a time and place that's most convenient for you. And we can hit the ground running when you come the first day of jury duty. First, we want to commend you for your willingness to volunteer as a youth court juror. The work that you will do as a juror is an incredible service to both your community and your peers. All youth court jurors are required to watch this training video before they'll be permitted to serve as a juror. When you arrive at your first youth court session, you will be required to sign a form confirming that you have completed this training session. Serving on a youth court jury is a privilege that we take very seriously. Please watch this video carefully. So, what is youth court and what is it exactly that you're going to be doing? There are more than 1,500 youth courts around the country. In fact, a quarter of all first-time misdemeanor juvenile cases are heard by youth courts, not juvenile judges. Why? Because we've learned that your positive peer pressure can be far more impactful than any punishment handed down by a judge. You are going to be hearing cases about your peers. You're all teenagers, and you can all understand and relate to the struggles of other teens far better than any adult judge. In every youth court session, you'll hear 4 different cases. Where do these cases come from? Well, here's how the process works. So, a teenager is arrested for a misdemeanor offense in Hamilton County. A misdemeanor is a minor offense, something like shoplifting or trespassing or fighting. A police officer fills out an arrest form and sends it to the juvenile court to be processed. The juvenile court looks at the cases and determines if the teen has been in trouble before. If they've never been in trouble, they refer the case to youth court. So you'll only be hearing cases of first-time misdemeanor offenders. Before they can participate in youth court, the teen, we call them the respondent, must admit their role in the offense. In other words, they have to take responsibility for their actions. Youth court is not about determining whether someone is guilty or innocent. All of the teens involved are taking responsibility for their actions. Your job as a youth court juror is to determine a fair punishment. We call it a sanction. If the respondent successfully completes youth court, so they have to attend the hearing and they have to complete whatever sanction you impose, the arrest will not be part of their official record. In other words, this is their one shot to wipe the slate clean and start over. If they fail to complete the sanctions or they get arrested again, they'll go before a juvenile court judge and face far more serious consequences. So how are these hearings structured? As I explained, you'll hear 4 different cases. Each case is approximately 30 minutes long. You'll hear 2 cases, have a break, and then hear the other 2 cases. Each respondent is assigned a law student advocate. That advocate will meet with them before the hearing to prepare their case. The hearing will start with a bailiff calling the court into session and reminding everybody about the confidential nature of the proceedings. We'll talk about confidentiality later. There will be a judge presiding over the hearing. The judge is not an actual judge, but is an attorney. The judge will not be deciding the case. The judge is simply there to preside over the hearing and to help you with your deliberations. Ultimately, determining a proper sanction is your decision as a jury, not the judge's decision. You'll hear first from a law student who will be acting as the prosecutor, and it's the prosecutor's job to explain the facts and circumstances of the case. The prosecutor will also make a recommendation for an appropriate sanction. Then the law student acting as the defense attorney will offer mitigating factors. We'll talk more about mitigating factors later, but basically mitigating factors are facts or circumstances either about the incident or the respondent that can help explain what happened and why it happened. Defense counsel may also talk about the character or personal history of the respondent. Defense counsel will also offer a recommended sanction. At that point, the respondent will be given the opportunity to make a statement. They're not required to make a statement, but it's their opportunity. And then it comes to your turn as the juror. You are given the opportunity to ask questions of the prosecutor, the defense counsel, the respondent, or even the parents. You might want to think about things like, are the facts of the case clear? Do you have enough information about the respondent? Do you want to get the parents' perspective? This is your opportunity to ask questions, and we encourage you to do so. After questions have concluded, everyone but you, the jury, and the judge will leave the room so that you can deliberate. Your deliberations are confidential, so you should feel comfortable to speak freely. You'll choose a foreperson who will be the spokesperson for the jury, who will help keep you on task and who will speak for the jury once you've decided on a sanction. You may use the prosecutor and defense counsel's recommendations as guideposts, but you are not required to adopt either recommendations. The ultimate decision about what the sanction should be is up to you, the jury. So that's a little bit about how the hearing process works. Let's talk now about confidentiality. Confidentiality is a set of rules or a promise that limits access or places restrictions on certain types of information. Youth court proceedings are confidential. The identities of the respondents are confidential, and your jury deliberations are confidential. So what does that really mean? Let's say you sit as a juror on youth court. You go home that night, your mom, dad, brother, sister, cousin, they ask you, so what was this youth court thing? What did you do? What did you see? What did you watch? What can you tell them? Well, you can tell them that you heard 4 different cases. You can tell them that 2 were shoplifting cases, that 1 was a trespassing case, that 1 was a fight. But that's about where the details stop. You can't talk about any information that would disclose the identities of any of the respondents. That information must be kept confidential. So for example, where did the individual go to school? Where did they live? What grade were they in? All of that information is identifying information and must be kept confidential. Let's talk now about conflicts of interest. As I told you, you're going to hear 4 different cases. And when you arrive for your youth court jury duty, a youth court staff member will tell you the names of the 4 individuals whose cases you'll hear. If you know any of the respondents, you'll be given the opportunity to alert a youth court staff member. We don't want you sitting as a juror if you know one of the respondents, because you could be biased. In other words, you may feel or show an inclination or prejudice for or against them. It wouldn't be fair for you to sit on their jury. If you have a conflict, you will simply sit out that hearing, but you will participate in the other 3 hearings. It is very rare for a youth court juror to have a conflict of interest and to know one of the respondents involved. It's not something you should worry about. It's just something you should be aware of. At this point, I'm going to switch to Anthony, who is going to talk more about mitigating factors and how to choose an appropriate sanction.
Thanks very much for that warm introduction, Katie. Again, my name is Anthony Holman. I'm a civil litigation attorney here in Cincinnati, and I want to talk to you about sentencing training and also the factors to consider when coming up with the sanctions we're asking you to impose at the hearing. What most people come to find is when you're sitting through these hearings, again, you've got 4 hearings that you'll be participating with, and what you will hear is you'll be hearing these people's life stories. You'll be hearing about their family lives. You'll be hearing about what's life like for them at school. If it's a trespassing case or a stolen property case, you'll be hearing about what circumstances went into that crime occurring. And what most people pay attention to right off the bat is the acceptance of responsibility that the respondent has. How sorry are they for their actions? And you can judge that by their verbals or nonverbals. During the hearing, the respondents will have an opportunity to present their version of the facts if they want to. I can tell you that oftentimes the respondents are very nervous. They're fearful of being judged by their peers, and oftentimes it's their attorneys that do the talking for them. And you can factor that into your decision or not. The other factors to consider, as you can see on your sentencing training outline, are age, health, family circumstances, extracurricular activities, employment record. Here are the 3 that I think are the most important to keep in mind. One is the motive. Why did they do what they do? Is it a matter of friends influencing their behavior? Is it a matter of they're short on cash and they're needing food? Is it a matter of other circumstances? You just don't know until you ask the questions. And sometimes that information is proffered by the attorney representing the respondent. And sometimes you're left wondering. And we encourage you throughout this process, especially when given the opportunity, to ask questions. Ask questions of the respondent. Ask questions of the attorney. If the person's parents or guardians are in the gallery, ask questions of them so that you have a complete picture of what took place and how you can best formulate the sanction that you think should be imposed. The other 2 considerations I think are important are prior incidents and punishments already imposed. So if it's a theft, has the person stolen before? If it's a fight, have they engaged in verbal or physical altercations before? You just don't know until you ask the right questions. And prior incidents, has it happened before? It seems like it's a question that you typically forget to ask because you're so caught up in the moment of the particular circumstances of why they're there that day. But while in a court of law, that sort of background information might not come in. In this particular case, you can ask whatever questions you want that you feel will give you the best background and guidance to formulate the right sanctions. So let's talk about the sanctions. What is it that is available to impose on these respondents? As you can see on your sanctions form, we have several outlined. They range in severity from an admonishment, so a slap on the wrist, essentially, all the way down to house arrest. These sanctions on the periphery aren't typically imposed, but if you learn throughout the case, for example, that the respondent's parents have done an adequate job of disciplining them at home, or the school has, then you may come to find that perhaps the person's already served what sanction's appropriate, and you decide that maybe they should just be told by their peers that what they did was not acceptable. All the way down to house arrest, where the person literally cannot leave their home unless accompanied by a parent or guardian for however long you believe is an appropriate length of time. There are other ones. The most common sanction imposed is the community service. And you can think about what this person does in their spare time. Maybe the person volunteers at a church. Maybe they volunteer at school. Maybe they volunteer at a local Boys and Girls Club. Maybe they mow yards in their neighborhood. Think about, when you're listening to the circumstances of their case, if you feel like community service would be an appropriate sanction, think about, where should the person serve their time so that, again, they can atone for the crime they committed and provide value to the community in doing so. Other sanctions typically imposed, a letter of apology or verbal apology. One thing to consider here, if it's a theft offense and, say, for example, they stole makeup at Walmart, they may not be welcomed in that store and be able to present that apology to the manager or to whoever the appropriate person is. If it's at school, maybe it's the dean or some other person involved. Find out whether or not they can still approach that person or write that letter, and if it's appropriate, then you can fashion that as a sanction. The other one that I like is serving as a jury member on youth court. Again, like Katie said, it's a privilege to be on youth court. It's a tremendous responsibility, an opportunity for you to meet with like-minded students your age, to meet with practicing attorneys. So if the person shows the appropriate amount of remorse, if they appear intelligent, that they treat the process very seriously, it could be a tremendous opportunity for that respondent to not only serve the appropriate punishment, but also be an important contributing member to a future youth court hearing. Lastly, I want to talk about the goals of why we impose these sanctions, why we even have youth court here in Hamilton County and the purpose it serves. The first and most obvious goal of youth court is to deter the respondent from ever committing another crime again. And the second, which closely follows that, is rehabilitating that respondent, helping that person not only understand what they did was wrong, but also paying the community back for the inappropriate actions that that person committed. The third goal of youth court is to deter others from ever wanting to commit the same sort of acts that the respondent did. And lastly, there is what we call retribution, but what it is more is it's about the community. It's about helping the community understand that that these people acknowledge what they did was wrong, that they want to make themselves better and in turn make the community better for what they've done. And in serving the sanctions, they not only make up for what they did, but they also make their community and the people around them better. And ultimately, the goal here is one of the goals is to reduce the recidivism rate. We want to make sure that these people never commit another crime in their life, and that this positive peer pressure environment will help them to realize the error of their ways and hopefully become contributing members to their society. So in conclusion, I want to thank you very much for watching this video. I hope you get everything out of it that we hope you do, that you have the opportunity to converse with your jury members, that you ask questions of the attorneys that are around you, and that it's a tremendous learning opportunity and experience for all. So thank you very much.